Session 1 is now in session.
Welcome. Please be seated. Good morning. We are here today for oral argument in case number CD 230096, Laffoon versus Safeway. Each side has 20 minutes for your argument this morning. The appellant may reserve time for rebuttal. I would just ask that you keep track of that yourself. There's a clock on the other end of the podium. Our proceedings are being audio and video recorded this morning, so if you could introduce yourself and your client, that would be appreciated. We've read the briefs, discussed the case in conference, and are familiar with the arguments raised, so please keep that in mind while you make your arguments. And with that, you may proceed, counsel.
Good morning. May it please the court, Jennifer Cranston and Kevin Neal of the law firm of Gallagher & Kennedy on behalf of the appellant, Ms. Maria Laffoon. I appreciate that you have read the briefs and are familiar with the factual and procedural background, and so with that, I'll jump into the heart of the appeal, and to give you a little heads up, there are two issues that I think are pretty key on this case that indicate that the trial court really did err in granting summary judgment. And the first is that the trial court applied the doctrine of open and obvious as a complete defense. And the second issue is the trial court ignored material issues of fact and inferences that should have been construed in favor of the plaintiff, Ms. Laffoon. On the first issue, the trial court applied her finding that the condition was open and obvious as a complete defense. And we know this because the minute entry is very telling. It states, and I'm reading, therefore, as a matter of law, the danger was open and obvious. Therefore, it is ordered granting a motion for summary judgment. The problem with this is that granting a motion for summary judgment based solely on a finding of open and obvious is inconsistent with Arizona law. Now, the defendants focused on a single case, and I'm not entirely sure how to pronounce that case. I think it's Darty, but I'm just going to call it the Montgomery Ward's case, just so I don't butcher some person's name out there. They focused on this Montgomery Ward case that for a lot of reasons isn't applicable, but to the extent that it is applicable, we have to read it in the context of all the other cases that came before and after it. So just
sure. At a very high level, with the negligence claim, you have duty, breach, causation, and damages. Where are we in this case? I think you, in your reply brief, you argue breach, and if so, why?
Thank you for that question, Your Honor, because I did not handle this case at the trial court level, and when I reviewed the minute entry in the ruling, I found it very curious that the trial court seemed to have decided this case as a matter of law on the issue of duty. And that would be an erroneous ruling as well, because as we know from, so many cases, that the existence of duty is based upon a relationship between the parties, and that it cannot be based on this issue of open and obvious as to what the scope of the duty was. So to the extent that the trial court based her ruling as a matter of law on the existence of duty, then that absolutely was an error and warrants reversal. So to give the trial court the benefit of the doubt, we have focused on the issue of breach, and it's really standard of care and breach. And we have significant evidence in the record indicating that there were material issues of fact as well as inferences that warrant sending those issues to a jury and not to be decided by the judge.
So, counsel, let me ask you, I would guess you'd say tribe is the controlling case here?
I think that is definitely one of the controlling cases, yes.
1982, Montgomery Ward, I think, was, in the 60s, 67? Why wasn't, or why isn't tribe no longer the law after Quiroz? I mean, so I think tribe talks about foreseeability and in the open and obvious context, Why isn't that no more after Kiraz?
I think that goes directly to the question that your fellow judge was asking, which is tribe is focused on what issues go to the jury, and that is the standard of care. The question of do we owe a duty, is there's an existence of a duty, was not disputed in this case. The question that the defense really focused on is what is that duty? And they characterize it as there's no duty to warn if the condition is open and obvious.
So you would say Kiraz preserves foreseeability, as I suppose it must, especially when the question is open and obvious, in everything but duty?
Correct, Your Honor, and I think that's reiterated. I know Kiraz is the most recent, but I don't think Kiraz is inconsistent with the prior case law, which is tribe, which is Markowitz. Markowitz versus Arizona Park Board is very instructive in this case because the Supreme Court in that decision very clearly held that you cannot look at the scope of the duty when you're deciding the existence of a duty. Scope of duty is something that absolutely has to go to the jury if there are any material questions of facts or inferences. And this proposition that if you can see this danger, right, or see the condition that is dangerous, therefore the defense has a complete defense and there is no liability, doesn't make sense when you look at Markowitz, when you look at tribe, when you look at the Court of Appeals decision in Johnson v. Tucson Estates. There we have a case where the Court of Appeals upheld a jury verdict in favor of the plaintiff. The plaintiff admitted that he was aware that the floor was slippery, and he in fact fallen in that very same place previously. So if the Montgomery Ward's case is truly what the defendants claim it to be, which is there's this absolute defense where the plaintiff is aware of a danger, then there's no way that these subsequent cases could have been decided the way they were, either at the trial court on appeal.
Safeway owes a duty because it's inviting the public into its stores and selling them goods. Where's the duty with Khalil? Because it's introducing products into stream of commerce, and those shouldn't be injuring folks?
Well, Your Honor, that wasn't briefed at the trial court level or at this appeal, but I would say that it was implicitly. One, Khalil has never claimed they don't owe a duty, and I believe it's because they are a possessor. When they are putting their products on that end cap space, they are a possessor, and they continue to owe that duty to the invitees that are going to be completely, normal. A person walking down an aisle sees cans at the top and is going to reach for those cans.
Right.
They aren't.
It just was a little confusing, and this may be a better question for the defendants, but it seemed like they're sort of being jammed together. So, for example, is there evidence in the record that Safeway saw the schematic before this all happened?
Yes, Your Honor.
Okay.
Yes, Safeway, I believe the evidence in the record and the deposition testimony was submitted in the plaintiff's statement of facts, includes deposition testimony indicating that they were aware of the schematic, they had reviewed it. It's somewhat, again, a fact issue for the jury. It's somewhat ambiguous as to whether or not they reviewed it with an eye towards safety, but that would be a breach, right? If they're supposed to be reviewing it with an eye towards safety and they don't, then they've breached their duty of care.
Yeah, I think you sort of anticipated my next question which was, do we know what the purpose of the schematic was, and was one of those purposes customer safety?
I don't believe that information is in the record,
Okay.
but that's certainly an issue. Markowitz goes through all of these issues, as does the restatement, which defendants in their briefings say we shouldn't look at the restatement. Well, that's a strange thing to say, because in Tribe v. Shell Oil, the Supreme Court explicitly adopts the restatement in this area on the issue of open and obvious. And so the restatement lists all of these factors that need to be considered, and open and obvious is obviously just one of those factors. But the question is, should the defendants foresee, which again is an issue for the jury, that an invitee is going to maybe see the danger but not understand the danger, not appreciate the danger, not take efforts to protect themselves? That's language straight out of the restatement. Or are they a reasonable invitee who is going to perceive a benefit that outweighs the potential risk. And I
They're just going to go for it anyway.
I say you're going to reach for those cans every single time, despite the risk. And being a 5'2" person, I reach for the can every time, despite the risk. And I think a jury would understand that. And maybe they would disagree with us, but at least it should go to a jury to make that decision.
And just to try to test how much work the schematic is doing, let's say that the situation in this case is slightly different, and they stacked the cans consistent with the schematic, but the same thing happened. Is there still breach?
There could be, and we'd have to look at the different factors there. Obviously, we have focused on the fact that they didn't comply with their own schematic, and we have the Safeway employee in the incident report explicitly stating, quote, Khalil stacked it too high, stacked the cans too high. So, you know, we're gonna take the layup, right, that indicates that they knew and they should have known that they were breaching their duty, and that just makes the plaintiff's case easier. But even if they hadn't, I still think there would be issues of fact that a jury should be allowed to determine as to whether or not even a 2-row is truly a reasonably safe condition. The other cases that I wanted to point out to you...
And I guess how would I go about figuring that out, whether it was safe or not? And maybe that's why judges don't do breach, but...
I think that's exactly why judges don't do breach. And we don't have a fully developed record on that particular issue because of the way this was presented to the trial court. But I can assure you, sending it back down to the trial court, those are issues that will definitely be explored. I would like to reserve some time, but I would like to point out just a couple other cases and interesting comments in those cases for your consideration. The other case that I think is really telling here is the McMurdy versus Weatherford Hotel, which both sides have addressed in the briefing, but that's a situation where the Court of Appeals reversed a trial court's summary judgment grant in favor of the defendant, and the court found that these issues, which were standard of care and breach, should be addressed by a jury. In so ruling, the court actually had two comments that I wanted to point out to you. One is that the court indicated that the Raji instruction on unreasonably dangerous condition actually includes language for a judge to instruct a jury on how to determine liability, quote, even if the condition was open and obvious. So that indicates that open and obvious cannot be a complete defense. The second is that the Court of Appeals criticized the trial court for relying upon an unpublished federal court decision because that federal court decision misapplied Arizona law. And I think that's somewhat reminiscent of the defense reliance on the Ross Dress for Less case. It's not entirely clear that is another case. That's a case where we have an almost completely undeveloped record, and the federal court there issued a ruling in favor of the defendant, and it's not entirely clear that it was all based on open and obvious. It seems like there was a lot of evidence lacking in that record, but to the extent that the federal court did apply open and obvious as a complete defense, I think the Court of Appeals in McMurdy would say you shouldn't look at that case because it's really not applying Arizona law the way it's supposed to be applied. The other few items I wanted to raise for your consideration are just to point to some of the facts in the record that the trial court just didn't really look at and construe in favor of Ms. Laffoon. In her testimony, and this is part of the record on appeal, in her deposition, she testified that when she saw the cans, they did not look unsafe. And so I'm not even sure we have an undisputed fact that this condition was open and obvious, because certainly to Ms. Laffoon, it was not open and obvious. She thought it was safe to reach for the cans. And then the other pieces of evidence in the record that indicate that this really should be a jury issue are the fact that while the defendants knew of the schematic and the standard on all the other, if you look at the pictures, on all of the other rows, they're only stacked 2 high, and we have the final row that's stacked 3 high. They were certainly aware of that standard, but our plaintiff, Ms. Laffoon, she is not in an equal position to understand what the difference is between those 2 stacking heights, and that the 3 stack creates an additional danger to someone like her. The other thing that is interesting is in that Johnson v. Tucson Estates case, the court pointed out that if you are dealing with invitees who maybe are on the elderly side, which Ms. Johnson, which was Ms. Laffoon clearly was, she's an 80-year-old woman going to her local Safeway to do her grocery shopping, that's another factor to be considered in determining whether or not the defense or the defendants should have anticipated that this condition was unreasonably dangerous. So I'm going to reserve, unless there are more questions you want to ask right now, I'm going to reserve a few minutes for rebuttal. Thank you.
Thank you, counsel.
Good morning, Your Honors. Good morning, Your Honors. May it please the Court, I'm Arcangelo Cello with Jones Skelton on behalf of Defendant Safeway, arguing as well on behalf of Defendant Khalil Bottling Company by agreement of the defendants. With me here at counsel table are Justin Ackerman, also of Jones Skelton, as well as Margaret Hoffmaster, who was trial counsel for Khalil, as well as in the gallery, Christopher Wilson, who was also trial counsel. Throughout the briefing, including on page 5 of her reply brief, plaintiff has conceded that defendants are correct about all of the material facts in this case, which are that plaintiff saw how high the cans were stacked, that she did not forget and was not distracted as she reached for them, causing them to fall. These facts put her squarely within the rule articulated in Doherty v. Montgomery Ward, which holds that even assuming that a condition is dangerous, there is no duty to guard against dangers that are as well known to the plaintiff as to the defendants, and therefore no breach.
Is that the same thing? The fact that she sees the cans is the same that she can appreciate the danger that 3 high poses as opposed to 2 high?
Doherty articulates an objective standard that depends only on the plaintiff's knowledge of the facts constituting the dangerous condition. It does not consider the subjective appreciation of the danger. Which was not considered at all in Doherty or in the cases that applied Doherty since then. Doherty, by the way, is not an outlier. It is not the only case that held the way that it did. It has multiple cases that have followed it, including Warfield v. Shell Oil, 106 Arizona 181, 1970. In that case, the plaintiff actually testified that she saw the muddy trench into which she fell, that she didn't know the full extent of how muddy it was, and she testified, "I decided this was not too wide for me to safely step across, so I continued my step." And in that case, the Arizona Supreme Court applied Doherty and affirmed a directed verdict in favor of the defendant, showing that the plaintiff's subjective appreciation or lack thereof of the risk involved is not material under Doherty. It's simply not considered. And part of the reason for this is that Doherty is a well-reasoned corollary to other established concepts in premises liability law, including the rule articulated in Price v. Sambos. In Price, they said that the relevant knowledge on the part of a defendant for imposing liability is knowledge of the facts constituting the condition, not the surrounding facts that may have caused it.
Is this a duty case or a breach case?
It is a duty case because Doherty decided that there was no duty. Now, the question of duty is closely related to breach when breach is decided as a matter of law, which it can be here because there are no material facts in dispute. So at that point, I'll admit that the questions are so closely related that the difference is almost semantic. But because there are no disputed material facts, breach can be decided as a matter of law as well as duty.
So, counsel, where's in Doherty, Montgomery Ward, where is the equivalent of the schematic here? The superior knowledge, right? You have open and obvious, but then you have an extra layer of knowledge. Where is the schematic
So this,
in Montgomery Ward that would allow us to compare that to tribe and apply it here?
well, Your Honor, I would argue that the absence of a schematic in Doherty shows that the origin of the condition or the background is immaterial under the test articulated there. In this case,
So there is no schematic there.
there isn't, because it's not material to the inquiry. In this case, plaintiff's arguments, depending on the schematic, all go to whether or not the condition is unreasonably dangerous. But the Doherty test assumes that the condition is unreasonably dangerous and says that the defendant is not liable, notwithstanding the unsafe condition, because plaintiff knew about the condition.
Okay,
And that,
let's talk about a later case by the Supreme Court, and that is Tribe v. Shell Oil. I can read from you what it says. I'm sure you've read it. Why doesn't it apply here?
because Tribe dealt with whether a condition is open and obvious, but the rule always states whether a condition is open and obvious or as well known to the plaintiff as it is to the defendant. Tribe dealt with in Tribe, there was an issue of fact as to whether or not the condition was open and obvious to begin with. It dealt with what the plaintiff should have known. In this case, we have an admission by the plaintiff that she saw the condition, that she saw how high the cans were stacked, that she never forgot or was distracted from that fact, and that she was looking at the condition and was aware of it as she reached. That knowledge is coextensive with any material knowledge on the part of the defendant.
But let's agree that they both have knowledge of something. The question, and I'll read directly from Tribe, is whether the owner should anticipate the harm from the condition despite its obviousness. And in that case, he may be liable. So here, the schematic is what I call superior knowledge. And so why isn't that on all fours with Tribe? The notion that, yeah, they both have knowledge, but if the defendant has superior knowledge, that is precisely what Tribe was talking about.
Well, this relates to the point that I was making before about the Price case, is that the relevant knowledge on the defendant's part is not about conditions that may lead to a dangerous condition. It's just the facts of the condition itself, not how the pebble got there or where it came from, but the fact that the pebble is there in the walkway.
What's Price? What year was that? In what court?
Price v. Sambos, I believe it was in the 60s in...
So 60s. Okay, this is a Supreme Court opinion from 1982.
Well, Price is the case that's cited in the Rajis as the bedrock principles.
Well, I don't
for
look to the
premises
Raji.
liability.
This court doesn't look to Raji. They look to Arizona law. Why isn't Tribe the law and on all fours?
Because Tribe dealt with the question of what's open and obvious. So whether a condition in its natural state is something that the plaintiff should be aware of, right? In this case, we're not dealing with open and obvious. We're dealing with an admitted actual knowledge. And because of that, it obviates the inquiry of whether or not a defendant should have anticipated the harm.
But Tribe also says where both parties have similar knowledge, if the invitor knows that the invitee is still going to take a chance and go for it, that the invitor is in breach.
Again.
And isn't the purpose of stacking those cans is that customers will purchase them? They'll go for it. I mean, a customer is not going to, you can't even get to the bottom row of cans. You have to go for the top row of cans. So I just don't see how that doesn't fit into that portion of Tribe, which I think at least puts a gloss based on the restatement second 343, puts a gloss on Doherty.
Well, the restatement comment E also says that when a condition is known, and we're not just talking about whether it's obvious enough for a plaintiff to notice it, but when the condition is actually known, an invitor has a right to assume that an invitee will behave accordingly and take reasonably good care of themselves. That's correlative to the invitee's right to assume that the premises has been made free of latent perils. When an invitee actually knows of the condition, it is no longer latent, and the duty of the invitor does not extend to that condition.
But what is the condition? Is the condition that there were cans or that there were cans stacked, overly stacked?
Well, it's in between Your Honor. It's the fact that the cans were there and that they were stacked as they were, right? It doesn't matter if the plaintiff knew about the difference between the schematic and as they were. Plaintiff knew the situation as it was, and her knowledge of that condition was equal to that of Safeway or Khalil, right? And again, relating to the Price decision, which is cited in the
Her
briefing.
knowledge was equal to Safeway or Khalil in terms of just where the cans were?
Of the fact that they were there as they were when she reached for them, yes. And that is the material.
Not that they would fall on her head.
Plaintiff's appreciation of the risk is not material under Doherty or any of the cases that applied it since.
So if I go into Safeway and I see cans stacked 3 high, I pick one up, one falls on my head, Safeway's not liable because I knew there were cans there?
You knew there were cans, you knew that they were stacked 3 high, and Safeway had a right to assume that you would act as a reasonably prudent person would. And the case law.
How is that? How would I just wouldn't reach for them? I wouldn't purchase the soda that I'm really thirsty for?
Well, any reasonable jury familiar with supermarkets knows that, you can ask for assistance, you cannot reach, you can look for them in a different spot. And that is up to the plaintiff who knows about the danger to assess. And again, the defendant's duty extends only to latent perils.
What if she asked another customer and then the cans fell on that customer's head?
Well,
I'm
assuming
6'4", people ask me at the grocery store to get things that are high up. If I do that and it falls on my head, no breach?
well, you would be in the same position as a plaintiff who saw the cans to act accordingly. With respect to the defendant's right to assume that a plaintiff will act accordingly, the case law tells us that, and it also tells us in the Burney case and in Cummings v. Prater that there needs to be a line between liability and non-liability.
So the act accordingly, that's not a jury question?
No, it's not, because Arizona law makes it an issue of law for the following reason. The case law tells us that there needs to be a line between non-liability, otherwise premises owners will become insurers of their invitees' safety and liable for all manner of accidents. The line has to be drawn somewhere. For example, in Doherty, in one of the cases that it cites, it says that the court is reluctant to advance a standard of due care to such an unreasonable length that would practically put every accident in the category of actional negligence or make a storekeeper the insurer of the safety of his customers. Premises owners are not required to make their premises absolutely safe. The case law says that. It's a bedrock principle. They're required to address latent perils, and the line is drawn at what the plaintiff knew. And
So your position is that if we don't say Ms. Laffoon's claim fails as a matter of law, and we're essentially saying that Safeway is an insurer of customers coming into its stores?
You're saying that even when a plaintiff sees the condition and proceeds anyway, that Safeway is liable for that accident.
Even when
Do you have any
Safeway
data-
is
do you have any-
no, good.
Do you have any data about how often cans fall on people's head in Safeway stores?
I don't, but by looking at the case law and comparing cases where the open and obvious and anticipated harm exception in tribe is litigated versus cases of pure Doherty questions, there are naturally more of the tribe cases than there are of the Doherty cases. But the rarity of a Doherty case does not mean that Doherty is incorrect. It simply means what the case law tells us, that when plaintiffs know, when invitees know of a condition, they're likely to act accordingly and not be injured. And in the rare case where they act anyway and they are injured, the defendant is not liable.
Without regard to superior knowledge, the defendant having superior knowledge, that's irrelevant in your mind. So they both have knowledge, but one has superior knowledge, that this can has been shaken and will explode. I mean,
The type of knowledge here is the type of knowledge material to liability. And under basic premises liability law, a defendant is liable when they simply have knowledge of the facts amounting to the condition. Doherty announces a correlative principle that says in order to defeat liability, the premises owner needs to only show that the invitee had the same material knowledge, which is the same type of material knowledge that would impose liability on the invitor, the knowledge of the facts amounting to the danger. Background facts of how it got there are not material. They may go to why the condition is unsafe, but Doherty assumes that question, and
Would
it's
you
not
agree with
disputed on a
me?
motion
The
for summary
Superior
judgment.
Court, in its minute entry, dismissed this case because the danger was open and obvious. Agreed?
Admittedly, the
Yes or no?
that is what the Superior Court
Okay,
stated.
tribe tells us, but if the owner should anticipate the harm of a condition despite its obviousness, he may be liable for the physical injury caused by that condition. Right? That's what it says?
That is what tribe says, but
How is the Superior Court not erring here, given the schematic and the incident report and the deposition testimony of the Safeway employee?
So the Superior Court didn't err because while tribe dealt with whether a condition was open and obvious and whether the plaintiff should have known about it, the Superior Court's holding depended on the fact that plaintiff was aware. She was aware of the height of the cans. They were not hidden in any way. And that's it. She had the relevant
Well,
knowledge.
but tribe says that's not it. Tribe says the fact that the injured party knew of the danger is not conclusive. So it's not it.
Tribe says knew
The
of the
fact
danger.
that the injured party knew of the danger, so going back to the phrase that my colleague cited, but if the proprietor should anticipate the harm from the condition despite its obviousness, he may be liable for physical injury caused by that condition. The fact that the injured party knew of the danger is not conclusive.
That statement in tribe is dicta because there was an issue of fact as to whether or not the condition was even open and obvious. The plaintiff in that condition undisputedly did not know of the condition. So if that statement is inconsistent with Doherty, Doherty and its progeny, where plaintiffs actually did know of the condition, it's dicta and not binding. I would like to quickly address the number of inferences that the plaintiff accuses defendants of improperly relying on, and which plaintiff instead is incorrect to rely on. First, as I've said, plaintiff's subjective appreciation of the danger is immaterial under Doherty and its progeny. Whether she considered alternatives is also immaterial. Again, it goes to her subjective assessment of the danger or not. It's not material. It was not considered in anything in Doherty or any of its progeny. In addition, plaintiff says that she disputes a supposed factual inference that Safeway should not have had to anticipate the harm. As we've discussed, that is a legal inference, not a factual inference, and the court does not need to reason in favor of plaintiff on summary judgment for that. And finally, I would like to emphasize that foreseeability is not at issue in this case because where a plaintiff knows of the danger, a defendant is entitled to rely on the fact that she'll act accordingly. And as a matter of law, plaintiff's knowledge obviates the foreseeability inquiry. And as a true final point, I would like to emphasize that Doherty is...
When you're trying to decide whether someone knew of the danger, aren't you necessarily analyzing for foreseeability?
No, because plaintiff admitted knowledge in this case.
I don't think she's admitted knowledge of danger. She's admitted knowledge of the cans being on the shelf.
Yes, she admitted that.
Right. So she admits there's cans.
And as a
on the
matter of
shelf.
law, that admission takes the place of a foreseeability inquiry because as a matter of law, a defendant is entitled to assume that a plaintiff will act accordingly in the face of known conditions.
But those known conditions have to be dangerous for us. It feels like you're skipping a step there.
The inquiry
And for us
assumes danger.
to decide whether those known conditions are dangerous, that feels like foreseeability to me.
No, because the Doherty inquiry assumes the dangerousness. All of the case law that Doherty cited said that even when a plaintiff knows, even when the condition is dangerous, if the plaintiff knew about it, then the defendant prevails. So on summary judgment, we can take all of those inferences in her favor. Doherty still means that the defendants prevail here.
Right, but I think you're still asking us to take the leap from knowledge of cans to knowledge of danger. And so, what am I missing?
But the case law says that when a condition is known, a plaintiff will act accordingly. Now, a plaintiff can act accordingly in the face of safe conditions or of unsafe conditions, but plaintiff is responsible for acting in a way that is justified by their knowledge. Okay? And finally, just pointing out two other ways in which Doherty is correlative to established principles of premises liability law. It complements, excuse me, sorry, I had this written down. I have mentioned all of my points, that it's...
One more question. Does Ms. Laffoon's age or height or any other physical trait have any bearing on this?
It doesn't, because a plaintiff is responsible for knowing about their own physical limitations and acting accordingly as a reasonable person would with those limitations. So that should not enter the analysis, no.
But how do I know as a judge what it means to act accordingly as an 83-year-old woman shopping at a Safeway?
The case law simply says that a defendant gets to assume that a plaintiff will act accordingly. Therefore, the premises owner has no duty and did not breach their duty when the plaintiff knew. That's not the inquiry. But thank you, and if the court, I'm out of time, so the defendants will rest on their briefs. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honors. I just have a few follow-up items, and I'll maybe even leave some time on the clock here. First, I want to thank Judge Cruz for reading from Tribe, because that quote from Tribe, in which the court clearly states that knowledge of the danger is not conclusive, I don't think it's dicta. I think it is exactly what the Supreme Court intended to rule there. I think the struggle here is trying to figure out, it's Doherty, Montgomery Ward, and trying to figure out how Montgomery Ward fits with these other cases. And I think Montgomery Ward and some of the other cases that were cited in the defense briefs are really dealing with kind of an unusual circumstance where there's unknown information, insufficient evidence about how the accident came to occur. In the Montgomery Ward case, this woman is taken back into an office. She sees the chair. She sees things are slippery. We don't know what went wrong. She doesn't even know if she tried to sit on the chair, if she fell. We have the same situation with the spilled milk case in the hospital. There's no evidence as to how the milk got there, and so what the court is struggling with in those types of cases, the Pebble case, how did it get on the sidewalk so that the person entering the restaurant would slip on it? They're struggling with, if we don't know if the defendant is truly responsible for the dangerous condition, how can we assign liability to them? And that's where you get this, well, if the plaintiff was aware of it, and the defendant, we don't really know if they knew there was a problem, well, then we can't make them the insurer of all liability. That may be the right case, and I don't think that the Supreme Court's decision in Montgomery Ward has been overruled in that context. The problem is that's not the context of our case.
So where's the equivalent of a schematic in Montgomery Ward?
There is no equivalent of a schematic in
So
Montgomery Ward.
that's why you're distinguishing?
Absolutely.
Okay.
And the court in the Montgomery Ward case went out of its way to say the plaintiff has not claimed that there was a defect in the chair, that there was a defect in the floor. She's just saying she fell, and therefore it must be Montgomery Ward.
I think that's the defendant's point, though, is that she didn't know about those things, and yet the Arizona Supreme Court still said she knew about the condition, and because she knew about the condition, there's no liability.
But she didn't claim there was anything wrong with the condition. She didn't allege that there was anything defective in the Montgomery Ward case.
Sure.
Here, we know there's a defect, and we know it's attributable to the defendants. I think...
What was the defect, 3 high instead of 2 high?
3 high. 3 high. And maybe 2 high isn't even right, if depending on the height of the overall end cap. I'm not going to presuppose that issue. Again, that's something I think should go to the jury. But I do think there's a way to reconcile what the Arizona Supreme Court did in that case and the Court of Appeals has done in the other cases that were cited in defense brief with our situation, they're just two different situations. And I think Tribe v. Shell Oil, Markowitz, Johnson versus Tucson Estates, that's addressing our situation, and that's why those cases really indicate that the trial court incorrectly granted summary judgment. Judge Judah, you look like you have another question.
No?
All right, then I'm going to leave 1:40 on the clock. Thank you so much.
Great, thank you. And thank you both for your very helpful arguments this morning. I think we're still in the morning. We will take the case under advisement, have a decision issued in due course, and with that, we are adjourned.